Hi students, the next chapter is company management. Company management is the art of getting things done through others. Then what is company management? It is managing the affairs of the company. The affairs of the company is managed by the directors and the managing director, because as we discussed earlier, company is a separate legal entity. It does not have any physical existence. So, the affairs of the company must be managed only through some natural persons. Those persons, they are called as the directors. So, the company is managed by the directors. Who is a director? A person having control over the direction, conduct, management or superintendence of the affairs of the company. A person having the control over the affairs of the company, he is called as the director. The next one is, who can become directors? As per the Companies Act, only individuals can act as the directors of the company. So only individuals can become directors of the company. Next one is the number of directors. The number of director, it is based on the nature of the company. In case of a private company, minimum is 2 and maximum is 15 directors. In case of a public company, minimum is 3 directors and maximum is 15 directors. In that, at least one person must be a women director. In case of a one-person company, there is only one director. These are the aspects regarding number of directors. Next one is number of directorship. Number of directorship means a person can act in how many companies as a director. That is, a person can act in maximum 20 companies as a director. This is regarding introduction to directors or the number of directors. The next important aspect in case of a director is appointment of directors. It can be done in the following 8 ways. Number 1 is the first director. First directors are those persons who act as the directors whose name is mentioned in the memorandum or articles of the company. If their name is not mentioned, then the subscribers to the memorandum will act as the first directors. They hold office till the first AGM. Next one is appointment by the members in the annual general meeting. Every year the director will be appointed in the annual general meeting. 2/3 of the directors will retire by rotation and the place of the retiring director will be filled in the AGM by the members. This is called as appointment by the members in AGM. Next one is the appointment of the new directors other than the retiring director. That the total number of directors, 2/3 will be retired by rotation. They will be reappointed. Sometimes some new persons will be appointed other than the retiring director. In that case, the new person proposed to be appointed must give a proposal in writing to the company, and the company must circulate among the members, and he must be elected in the meeting, in the AGM. This is appointment of new director other than the retiring. Next one is appointment of independent directors. Independent directors are those directors who, in the opinion of the board, is a person of integrity and possess relevant expertise and experience. He hold office for 5 consecutive years. Every listed company shall have 1/3 of the total number of directors as independent directors. Next one is appointment by board. The board will appoint directors. In case of additional directors will be appointed. Apart from the total strength, some additional director will be appointed if there is any important projects like that. Next one is, if any casual vacancy like death or resignation or retirement of the director arises, it will be filled by the board. Next one is the alternate directors. If some directors were going to abroad for some business purpose like that, in that place some alternate persons will be appointed. Next one is appointment by third parties. Third parties are the debenture holders or the creditors for the matters relating to their decisions. some persons will be appointed for representing the third parties, that is debenture holders and the creditors. That is appointment by third parties. Next one is appointment by proportional representation. This is the appointment of directors by way of voting. The total number of in the total number, 2/3 will be appointed by way of proportional representation. Next one is appointment by small shareholders. To take care of the decisions regarding the minority shareholders, a director will be appointed to represent their rights. This is appointment by small shareholders. Small shareholders are shareholders holding not more than the shares of rupees 20,000. This is regarding appointment of directors. Then the next important aspect is removal of directors. The removal of directors, it can be done by the shareholders in the annual general meeting by passing an ordinary resolution before the expiry of the period of office of the director. In that case, a notice to be served to the director 14 days before the meeting regarding the resolution for removal, and that copy of the notice must also be served to the members regarding the removal. Then the director concerned, he can make a representation and justify his part, what is the situation. Then if the representation is correct and he justifies that, then he cannot be removed. Otherwise, if he is not able to justify, then he will be removed from the office. The representation given by the director must be circulated among all the members, and if it is justified, he will not be removed. Otherwise, he will be removed and some other person will be appointed in the place of the removed director. This is regarding removal of directors. The next important aspect in case of director is qualification and disqualification of directors. Regarding the qualification, first one is he must be an individual. Second one, he must be competent to contract. Competent to contract means he must not be a minor. He must not be an unsound minded person. He must not be disqualified by any law. Then last one is he must have Director identification number. Director identification number is the number allotted by the central government. Without the number, a person cannot act as a director. This is regarding qualification of directors. Next one is disqualification of directors. Here, the following were the persons who cannot act as a director. That is unsound minded person, insolvents, convict is imprisoned person, then a person without din, a person having calls in arrears for more than 6 months in the company, then a person has not filed a financial statement with the registrar of companies for a consecutive period of 3 years. These are the qualification and disqualification of directors. The next important aspect in case of company management is powers of directors. The powers of the director can be divided into 4 heads. Number 1 is the general powers. Number 2 is the power to be exercised in the general meeting. Number 3 is power to be exercised in the board meeting. And number 4 is restriction on powers. General power is the director is having the power to do any act which is authorized by the Companies Act and memorandum and articles. That is, he must not do any act beyond the memorandum, articles and the Companies Act. That is Ultra Vires Act. So the general power is power to do any lawful acts. Next one is the power to be exercised in the general meeting. The director has certain powers to be exercised in the general meeting. Number 1 is power to make calls on shares. Next, number 2 is power to issue debentures. Number 3 is power to borrow money otherwise than on debentures. Number 4 is power to invest the funds of the company. And number 5 is power to make loans. Next one is the power to be exercised in the board meeting. Directors have certain powers that they will be exercising in the board meeting. That is, number 1 is to fill the vacancy in the board. That is the casual vacancy like that. Next one, to sanction or give the consent for the contracts in which the directors are interested. Next one is to receive the notice of disclosure of the directors interested in any contracts. Next one is to appoint managing director, manager of the company, and to make investment in the companies of same group. These are the powers which will be exercised in the board meeting. Next one is the restriction on powers. Restriction on powers is the directors can exercise certain powers with the approval of the shareholders in the general meeting. The following were the things. Number 1 is to sell or lease or sell or lease the whole of the undertaking. Next, to give time for repayment of any debt due to the company. Next one is to invest the compensation received by the company in respect of the compulsory acquisition by any government, like that. Next, to borrow money exceeding the aggregate of paid up capital and reserves, that is borrow beyond the limits. Next, to contribute to any charitable funds exceeding rupees 50,000 or 5% of average net profits. Next one, to contribute to any political parties amount exceeding 7.5% of the net profit. These are the powers of directors. The next aspect is duties of directors. The duties can be divided into two. One is statutory duties and another one is non-statutory duties. Statutory duties are duties as per the Companies Act. As per the Companies Act, the directors have the following statutory duties. Number one is duty to supervise, control and direct the managing director or manager. Next one is duty to deposit all the money received regarding the issue of shares. Next one is duty to see that there is no false statement in the prospectus. Next one is duty to convene the extraordinary general meeting as and when required by the requisitionist. Next one is duty to approve the annual accounts. Next one, duty to recommend dividends. Next, duty to disclose interest in the contracts. Next one is duty to disclose the shareholdings in the company. These are the statutory duties as per the Companies Act. Next one is the non-statutory duties. These are the duties which are generally to be complied and not as per the any act or law. That is, number one is duty to maintain the fiduciary relationship. Next one is duty to take care and skill. That is, regarding fiduciary relationship is he stands in an important position. So he must maintain his dignity and he want to carry out all the lawful acts. That is duty to maintain fiduciary relationship and duty to take care and skill. This is regarding duties of directors. Next one is liabilities of the directors. The liabilities of the directors can be divided into three. Number one is liability as a shareholder. Liability as a shareholder, he want to pay all the amount due in his shares. His liability is limited up to the face value of the shares held by him. Next one is liability to the company. The director is held liable to the company in case of breach of fiduciary duty, that is breach of trust. Then for any ultra vires act, he is liable to the company. And for negligence is carelessness. If he is careless regarding his work, then he is liable to the company. Next one is criminal liability. The director is held liable for some imprisonment or fine or both in the following cases. That is, for filing any misleading statement, misleading prospectus, accepting deposit in excess of the limits. Next, failure to file return of allotment. Then if he is not maintaining the register of members or debenture holders, he is criminally liable. Then if he is failed to disclose the shareholdings in the company, then he is criminally liable. Then if he is not conducting the AGM or statutory meeting like that in time, then he is criminally liable. Then if he has given any false declaration about the solvency of the company, then he is criminally liable. These are the liabilities of the directors. The next important aspect in case of a director is position of directors or the legal status of the director. As far as a company is concerned, the director stands in a very important position. It can be explained below. Number one is director as an agent, because he acts on behalf of the company, because company is an artificial person. So he acts on behalf of the company. So he acts as an agent of he is the agent of the company. Next one is director as an employee. For his acts, he is getting remuneration from the company. So he is an employee of the company. Next one is director as officer. In certain cases, he is paying penalty as an officer. So he is an officer of the company. Next one is director as a trustee. He stands in an important position. He is a trustee of the company's money and property. He takes care of the money and property of the company. So he is a trustee of the company. So the director, he acts as an agent. He acts as an employee in certain cases. He is an officer in certain situations. He is a trustee in certain situations. So he stands in a very important position of the company. That is the legal status of the company. Then regarding the important questions are repeatedly asked in the university examination. Regarding first one is the appointment and removal of the director, or the powers, duties and liabilities of the directors, the qualification and disqualification of director, and the position of the directors. These are the very important aspects repeatedly asked in the university examination. If you are interested in the above video, you subscribe to my channel, you give your likes, you give your comments. Thank you. Next.